So welcome everyone. In this video, my goal is to provide you a brief overview of the criminal justice process, specifically an overview of how a case or an arrest gets processed through the Alaska criminal justice system and the Alaska court system. The criminal justice process in Alaska and nationwide is this effort to strike a balance between societal's need to hold offenders accountable and ensuring that the constitutional protections are met and that defendants and the accused are not held accountable unless the government can meet its burden and prove every essential element beyond a reasonable doubt. This is the presumption of innocence. The procedures that are reflected in this video really show the balance between public participation in the criminal justice system and protecting the rights of the accused. The Alaska criminal justice system and its structure is highly unified. Alaska is unique in the sense that our law enforcement, our court system, and our correctional system are all unified. The criminal justice system, of course, is made up of three parts: the police, the courts, and the corrections facilities. And law enforcement in Alaska, we have a statewide law enforcement with general jurisdiction, which is different than most states. The Alaska State Troopers are not limited in their jurisdiction to, say, highways, but instead have jurisdiction, in fact, the primary law enforcement responsibility for most of Alaska. They have primary law enforcement responsibility for most communities unless a city or borough police department has accepted responsibility for a particular area. For example, the municipality of Anchorage. We have no borough, city, or county courts in Alaska. All courts fall within the Alaska court system, and we have the Department of Corrections that has the primary jurisdiction of housing all prisoners, both pretrial and post-trial in Alaska. There are some city and community jails in Alaska, but even those city and community jails are under a DOC contract. The federal system is similar, where you have federal law enforcement, and you have the federal district court, and then finally the Federal Bureau of Prisons. But most states operate at the county level. They do not operate at the state level. This video is not going to go in and explain the difference between the Alaska highly unified criminal justice system and most other states. I will leave that to another day. You all know about the criminal justice funnel, and that more arrests occur than individuals who are formally charged in a case. More individuals are formally charged than are arraigned. More are arraigned than go to either a preliminary hearing or a grand jury, so on and so forth. This funnel continues along the criminal justice spectrum and through the Alaska court system until the very end. The criminal justice process always starts with an arrest or a criminal complaint in which the accused is summoned into court. So there are two starting points, which are very similar: the arrest, when somebody is immediately taken into custody, and the summons, when somebody is requested that they come to court. Shortly after the arrest, a legal document has to be filed by law. It's usually called the criminal complaint or the criminal information. That legal document is required to provide notice to the accused. It lists the charges the accused is alleged to have occurred or to have committed. It lists the legal elements of the crime. It lists the supporting facts, in other words, probable cause. And it provides for the statutory framework that lists the penalties. It may not, in fact, actually describe what penalties are at issue, but it would provide for the possible penalties within the classification system. This filing of the legal document initiates the criminal case. In Alaska, that criminal case, that criminal complaint, is either filed by a police officer upon arrest or a prosecutor who then seeks to have an arrest warrant issued or seeks to have a summons issued. Once somebody is either arrested or they're served a summons, they come to court either voluntarily or involuntarily. And once they're in court, that first court hearing is called an arraignment. The arraignment is where the judge formally informs the defendant or the accused of the charges against him or her. It's when the judge considers bail and pretrial release. It's where the judge ensures that counsel has been appointed, and if the accused cannot afford counsel. And finally, the judge at the arraignment ensures that the facts as outlined in the original charging document support a finding of probable cause. If a judge determines that probable cause is not found or does not exist as a result of the facts outlined in the original charging document, the court will dismiss the case without prejudice. The accused has one of three options, or in other words, one of three possible pleas. The accused can plead not guilty, the accused can plead no contest, or the accused can plead guilty and go immediately to sentencing. After the arraignment, the case is then set for either a preliminary hearing or a grand jury. In Alaska, all felony matters must be presented to the grand jury unless waived by the accused. Preliminary hearings, which are provided for by rule, are infrequently used, but they can be used when the grand jury cannot be scheduled soon enough. And the preliminary hearing, in short, is designed to ensure that there is additional probable cause to warrant that the defendant be held to stand for trial. A preliminary hearing is a quasi-mini trial. The judge is present, the defense attorney is present, the prosecutor is present. The prosecutor is required to put on witnesses, and that witness is not to show that the accused is guilty beyond a reasonable doubt, but instead to show that necessary to show that probable cause to support the charges be filed. A preliminary hearing is not required in every state. In fact, a lot of states don't have a preliminary hearing system. In Alaska, we are unique in the sense that we have both a preliminary hearing system and a grand jury system. The grand jury is a process in which 18 citizen members come together in secret, in where the prosecutor presents the case to ask the 18 panel members whether or not sufficient evidence exists to warrant trial in the matter. It is essentially a citizen-led preliminary hearing. One of the differences between the grand jury and the preliminary hearing, however, is that the grand jury, there is no judge and there is no defense attorney. Whereas at a preliminary hearing, the defense attorney can ask the prosecutor's witnesses questions through cross-examination. That right does not exist at the grand jury. The grand jury will review the evidence. If the grand jury as a body determines that the evidence is sufficient to warrant a trial, it'll return what's called a true bill. That charging document is also called the indictment. Another role the grand jury has in Alaska is in its investigative function. The grand jury in Alaska has the constitutional authority to investigate matters of public welfare and issue a report. After either a preliminary hearing has been held or the grand jury has returned a true bill, the case proceeds towards trial, and at the next stage is where the accused can file pretrial motions and seek an evidentiary hearing, moving to either suppress evidence, limit the introduction of certain evidence, move for the dismissal of the charges, argue that legal principles like double jeopardy or speedy trial preclude the government from moving forward, seek to change venue, or move to sever charges that have been improperly combined. Once the case moves towards trial, the first step in the trial process is jury selection, or otherwise known as voir dire. The purpose of voir dire is to determine if the prospective jurors are eligible to sit, and to ensure that they do not have a prejudice or a bias that would make it unfair for them to sit on the case. That prejudice or that bias is applicable both to the accused and to the government. So both the government and the accused have the right to ask prospective jurors questions to ensure that they can follow the law and render a true and just verdict. The jury must be drawn from a fair cross-section of the community where the crime has occurred. Once a jury has been impaneled and sworn, the case moves to what we routinely refer to as trial. Trial has multiple parts. The trial starts with an opening statement by the prosecutor. The defense has the right to provide an opening statement, or that has the right to reserve that opening statement. The prosecutor presents its case in chief. The defense has the right to cross-examine and put on its case. The government then has the right to rebut that case. The case moves to summation or closing, and where the parties get to argue about the facts and to point out to the jury which facts support its theory of the case, and to where the prosecutor argues that it's the facts support a finding of guilty beyond a reasonable doubt. After summation, the jury gets to retire and begin its deliberations. Deliberations is a secret process in which the jury is free to consider the evidence and determine its verdict without oversight by the judge, by the litigants, or by the accused. Once the jury has reached its decision, it will come and announce its verdict in open court. That verdict is either guilty, not guilty, or it cannot decide. If a jury comes back and announces that it cannot decide the case is determined to be a hung jury and a mistrial is granted. If a accused is convicted following a jury trial, the case moves to sentencing. In Alaska, sentencing requires a pre-sentence report. This is by court rule, in which the Department of Corrections will conduct an investigation to acquire information about the defendant, in which would aid the court in sentencing the defendant. At that sentencing hearing, the defendant has the right of allocution, or the right to explain the crime. The judge has the right and has the obligation to consider a broad range of information, both the direct consequences of the conviction towards the accused and also the collateral consequences to the accused. Also, the judge has the obligation to consider the victim's view of the offense. The judge has an obligation to allow the victim to make a victim impact statement, and the judge has an obligation to consider restitution. In Alaska, sentencing is governed by the presumptive sentencing guidelines, in which, by classification, all criminal offenses have a presumed sentence. That presumption can be overruled with the finding of certain facts or evidence, but the presumptive sentencing is truly designed to ensure that a similarly situated defendant receives a similar sentence. Once the defendant has been convicted at trial and sentence has been imposed, the defendant has the right to appeal that sentence. During the appellate process, the accused has the right to challenge the judge's findings on motions to suppress, other legal principles like sufficiency of the evidence, double jeopardy, violation of any other constitutional rights, and the like. Interlocutory appeals occur very rarely, and what I mean by interlocutory appeals is that those appeals that occur in the middle of trial or before trial begins. If somebody is held on a bail amount that they cannot afford, that they think is unreasonable, the accused has the right to petition the Court of Appeals on an interlocutory basis to seek a reversal of that bail decision. Similarly, if a defendant is found to be competent for trial, and the defendant wants to challenge the finding of competency, the defendant has the right to petition the Court of Appeals for a finding of incompetency and have that competency finding reversed. After trial and after sentencing and after the round of appeals, the defendant may have post-conviction remedies. Post-conviction remedies are collateral attacks or indirect attacks on the underlying conviction. They are only available after the exhaustion of all direct appeals. They cannot be used as a substitute for the direct appeal. In Alaska, there are two methods in which somebody can seek post-conviction relief. One is the petition for post-conviction relief. This is a statutorily created remedy. A petition for post-conviction relief is limited by statute both in scope and in time. It is a quasi-civil matter. The second process in which a defendant can challenge, the underlying conviction, is one of habeas corpus, which is also a civil, non-criminal lawsuit in which the defendant asks the court for a writ on the grounds that he or she is being unlawfully detained. So again, the purpose of this video was simply to walk you through how a criminal case progresses through the criminal justice system, specifically the Alaska court system. I hope you found this information helpful. I will be posting additional videos in the future. Thank you.